Taxi Tours versus Go New York Tours.
Good afternoon, Your Honors. May it please the Court. I am Maurice Ross from Barton LLP. May I please reserve 3 minutes for rebuttal?
Yes, sir.
Your Honors, in the modern world, in every industry, we see emerging duopolies and monopolies. This case is all about an attempt by the respondents to create a duopoly in the New York market.
So, counsel, in the complaint, are you asserting that that complaint, liberally construed as is required under our law, sets out allegations of a conspiracy, an agreement, an arrangement, all of the above? What's your position on that?
It alleges an arrangement under the Donnelly Act. It alleges a conspiracy. But we think the allegations are more than sufficient to draw an inference of an arrangement.
How specifically? What specific allegations?
Your Honor, okay. First of all, the complaint identifies a large number of attractions in the multi-attraction market from which Go New York has been shut out, number one. We identify them by name with specificity. And obviously, we identify the time period over which this has occurred. Second of all,
I'm concerned about the concerted action. Which allegations
yes,
specifically
well,
speak to
for
that?
example, Your Honor, we actually allege that this case involves not merely parallel action, but horizontal concerted action. For example, with regard to the One World Observatory.
The horizontal is generally thought of as less suspicious than the vertical is thought of as less suspicious than the horizontal.
Correct, and we allege horizontal.
Right.
And,
I've got it backwards, I'm sorry.
And here's
The
how this works.
horizontal is not as disfavored as the, do I have them? No.
As vertical.
Sorry.
I think the word, Your Honor,
The
Judge
vertical
Wilson, I
is
think is vertical.
easier. Vertical restraints are not viewed as unfavorably as horizontal ones.
That's true, Your Honor, although both tend to be evaluated under the rule of reason.
Yes.
But it is correct. And the issue here, and what I think the lower courts ignored, is that this complaint alleges horizontal with specificity. And here's how it works. In paragraph 37, we talk about the One World Observatory. Paragraph 37 of the complaint, it's at the record, page 69. We talk about the fact that Gray Line and Big Bus share this particular attraction, and Gray Line has exclusive rights to it. Even though Gray Line has exclusive rights, it shares that attraction with Big Bus, but Go New York is shut out. So here we have a waiver of exclusivity. That is horizontal
Okay,
conduct.
shut out, and the allegations of that shut out are what?
The allegations are that when Go New York applied to each of these attractions, including that one, they were told that the attraction people were told, if you do business with Go New York, we will stop doing business with Big Bus and Gray Line. And the complaint alleges with specificity that this happened time after time with attraction after attraction throughout the industry. And so we believe, Your Honor, that at least supports an inference.
So the complaint is sufficient because of that, because you allege that you were told by some representative, right, some representative of those attractions, that if they do business with you, they will not be able to do business with these other companies.
That's right. But also,
That's the heart of the complaint,
it
yes?
is, the heart of the complaint
understand.
is also that there's a pattern. This doesn't just happen one time. This happens everywhere throughout the industry. Go New York is shut out of the attraction pass market because of this conduct. I respectfully
Well, how many
submit,
attractions do you refer to in the complaint?
well, we refer to, I don't know the exact number, but 8 or 9 or 10. I mean, we have Top of the Rock, One World Observatory, Madame Tussauds, the Intrepid Museum, Broadway Inbound, Coach Short Line. We identify each of these, and the same thing happens every time. Now, I submit, Your Honor.
So then you're saying it's these allegations in the complaint that a representative from certain attractions has said, if we do business with you, we will not be able to do business with them.
That's
And
correct.
and they have said that's the reason why they will not do business with you.
Correct.
Okay,
And-
I'm sorry, those are those allegations, and then you're saying you have additional allegations, that it is a broad, right, this is broadly the experience of your company, of your
Correct.
client.
And it even involves attractions
So
where
the,
one or
sorry,
the
so the
other.
attractions are examples,
Correct.
okay? You say it happens broadly. So when it happens broadly, is that also true because a representative of those attractions, these other attractions, kind of broadly out of the market, has made the same or similar statements, again, that if they do business with your client, they will not be able to do
Yes.
business with these other companies?
Yes, we allege that very specifically throughout the complaint. And here's the thing. I think that should be sufficient at the pleading stage to draw an inference of a potential conspiracy arrangement.
Do you allege anywhere why or how or when the representative from those attractions came to this understanding, this knowledge, that if they do business with your company, or with your client, excuse me, they will not be able to do business
Yes,
with the
Your
other
Honor.
companies?
We allege that either Big Bus or Gray Line, in every instance, told them
Okay?
that if you do business with Go New York, we're going to pull our contract with you.
So suppose that is done unilaterally by Gray Line. Let's just take Gray Line for a second. Is that sufficient evidence of a horizontal conspiracy or an arrangement?
No, Your Honor. This is
Is
not
it-
a case
is it
where, this
evidence
is
of a-
distinguishable for example, State versus Mobil Oil, which I think the court correctly decided that case. That involved unilateral action. This is distinguishable from that case. Very important. That case was unilateral action, but we are alleging a conspiracy, and we have a real basis for it. And the key to this is these attractions where both Big Bus and Gray Line operate, but one or the other has exclusive rights, and yet they waive those exclusive rights to permit both of them to share that attraction, but not Go New York.
But where are your allegations that the action is concerted?
For example, well, in paragraph 37, for example, we talk about the fact that the One World Observatory is shared despite an exclusive relationship. So that shows that there has to be something going on there. There had to be a waiver of exclusivity. That shows
You're basically
exclusivity.
saying that there's an inference that can be drawn given the nature of the relationships up the chain, as it were.
I think it's more than an inference. In other words, I agree with Your Honor that an inference can be drawn. But here we have exclusivity in the hands of one party. They allow the other party in. They know that both parties are sharing. I mean, this is a small industry. It's not like they're blind to the fact that they are sharing this attraction. They know that. So there had to be a waiver of exclusivity. That is a concerted action. And I think, let me come back to the
Because they don't object? Because they don't object to the entity that has the exclusive rights?
Sure.
Or the
and
non-exclusive
yes,
rights, I'm sorry. The entity
Judge
that
Rivera-
doesn't have the exclusive rights to be able to have the attraction listed on, the stop on, stop off, hop.
Yes, that's
hop on,
correct,
hop off
Judge
access.
Rivera, but also because they have to know about it. And the attraction, unless the attraction had
They
permission.
may know about it, but do you assert anything else? I mean, they may know about it.
Well, no, we don't, but this is the problem with the decision of the lower court. They say, well, you don't assert the discussions. They use the word discussions, both in the First Department and the trial, Judge Schechter, the trial court. Where are the discussions? Where are the meeting minutes? You don't say when the meeting occurred, with whom. I don't believe respectfully, under the liberal pleading standard in this court, we have to go that far. That's
They didn't-
asking us to prove the case at the trial.
Justice Schechter didn't say there was an absence of minutes. I mean, she specifically noted that there was a failure to identify a specified place, how, to whom, who did it. There are no allegations concerning the specifics of the arrangement or the collusion or whatever it is.
Well, respectfully, I think that's incorrect. I think the complaint.
Wait, that there are no allegations?
There
or-
are allegations that identify each attraction over which period of time. There's even that, for example, in paragraph 37, we We identify Mark Marmerstein, the president of Grayline. There are very specific allegations, but I would also submit, Your Honor, that at the pleading state, this is a notice pleading state. The Donnelly Act is supposed to be supporting the broad policy of maintaining free competition in New York markets. I think the pleadings that we have that identify all of these attractions, that identify some at least concerted activity, should be sufficient to allow us to get into discovery and to
So-
get beyond the motion to dismiss.
Is that your argument, that your allegations represent the extent of what you know, and they're sufficient on their face, and you need discovery to fill in the blanks?
Yes, Your Honor, and here's the thing. As a matter of public policy, attorneys such as myself ought to be encouraged to enforce the antitrust laws and to take steps to support free competition in the market. And I think what's happened here is the courts have been too reluctant to allow these cases to go forward into the discovery phase. I think we should be permitted, given this pleading is more than sufficient, I think, to support an inference of concerted action and anti-competitive action. And let me say one thing.
The federal court didn't allow you to go forward with essentially these allegations, right? But said, try them out in state court, effectively, right?
Correct.
So why is it that you can succeed here and not there?
Well, thank you for that question, Judge Wilson. The pleading standard in federal court is much stricter. And in federal court, the judges are encouraged to look at whether or not there might be a rational, good faith reason for this conduct, okay? I submit that in New York State, the decision about whether there might or might not be a rational reason for this conduct or for this concerted action is a question of fact that should be determined by the jury. It should not be determined at the pleading stage. And in Judge Schechter's opinion and in the First Department's opinion, they talked about the fact, well, there may be rational reasons for this conduct. Well, that's true. We acknowledge there may be rational reasons for this conduct. We don't believe that's the case. We think the conduct was in bad faith and was anti-competitive. But those are questions of fact
So
that should
are
be
you
decided by
saying-
the jury.
So are you saying because here, taken as true against the non-moving party, viewing
That's-
that's why you could succeed in state court or be able to at least proceed at the initial junction?
Yes, I think so, Your Honor. I think that's true. And also, the Donnelly Act is broader
But
than...
counsel, just to the pleading point, didn't the appellate division find in this case that nor does the record support Go New York's contention that Supreme Court applied the more restrictive federal pleading standard?
Well, the First Department said that, but I think if you examine both the First Department's opinion in substance and the trial court's opinion, the trial court talks about discussions. You haven't shown discussions. And the trial court goes on about how there may be rational reasons for this behavior. But that's a determination of substance at the pleading stage, and I believe under the
Well,
policy of New York, that's
what-
improper.
What's the conspiracy arrangement that you say is inferable? Are you saying the other two entities got
Big Boss,
together, talked
yes.
to each other, and put pressure on the representative from, the observation tower, whatever you want to call it?
Correct. The theory in this
No,
case,
and was that an allegation you made?
absolutely, the theory, the basic
Where
theory.
is that? What paragraph? What paragraph?
I'm not sure, that's the basic theory of the complaint at the very outset. The theory of the complaint is that Big Bus and Gray Line conspired, or agreed, or engaged in arrangements to shut Go New York out of the attraction market.
But
And they-
again, that's based on the fact that a representative from one or more attractions, fair enough, said to you, if I do business with your company, I will not be able to do business with these other two companies.
Correct, and we've alleged throughout the pleading.
It's not that the other entities said something, whispered something to your company.
No, we don't have a
correct?
smoking gun that
No,
says
no, I
there was a meeting.
understand.
Yes.
yes.
But
I
it's because Go New York was told, in every place they turned in the market, that either Gray Line or Big Bus said, if you work with us, we're going to stop working with you. We're going to cut you out. And then that even occurred on attractions where the two share the attraction. So I think it is reasonable in that circumstance to infer a conspiracy.
So the nub of the relationships is you have several tour companies. Each tour company has a purportedly exclusive relationship with an attraction. and they enforce that exclusivity as against you, but they don't enforce the exclusivity as against one of the other defendant tour companies. Do I have that right?
You have that right. That's one part of the allegations of the
Okay, what's
complaint.
the other part
The other
then?
part is that aside from the attractions that have these exclusive
Yes.
relationships, there are other attractions that are not exclusive, but nonetheless, Go New York is shut out because they have relationships with both of the other defendants, but not Go New York.
So from the pattern of relationships, I take it you're alleging that the attractions have with the defendant tour companies, you think that's sufficient to put together either conspiracy or an arrangement?
Look, yes, Your Honor, it makes
wanna
no
make sure I
sense
understand the theory.
from an economic point of view. It makes no sense, in my view, for each of these attractions to say, we're not going to do business with Go New York.
Just one other question, if I can. What is the difference, in your view, between what's required to allege a conspiracy and what's required to allege an arrangement?
I think that's an important question, Your Honor. I think under, this court under State versus Mobil Oil framed the issue as follows. There has to be proof of a concerted reciprocal commitment. And I think the term commitment itself is somewhat ambiguous. I would say that there has to be a reciprocal arrangement that involves mutual benefits. That is, the parties have a mutually beneficial
How's that
relationship.
distinct from a conspiracy? What's the difference between the two?
Because a conspiracy or an agreement reflects something more formal. There doesn't have to be a meeting of the minds that, like such as a criminal conspiracy. There can be an informal, implicit arrangement which is mutually beneficial. I see my red light is on. I'd like to finish this one thought.
Yes.
I think the concept of mutually beneficial really is what the State versus Mobil Oil standard should be clarified. If you clarify it that way, then you look at the allegations in this complaint, I believe they are sufficient to allow this case to go forward. Thank you, Your Honors.
Thank you.
Good afternoon, Your Honors, and may it please the Court. I'd like to start to correct something that Mr. Ross said. There are no allegations at all in the counterclaims that specifically name Gray Line, Big Bus, or any other counterclaim defendant as ever having said, we'll cut you off if you work with Go New York. That's simply not there.
Well, why isn't your adversary right that at least you can raise the inference of concerted action with this idea of exclusivity that's only exclusive to everyone else except each other? Why isn't that enough?
Sure, I'd be glad to address the theory of waivers of exclusivity. To begin with, it's only alleged for 2 of the 10 attractions named in the complaint. And there are no facts in the pleadings that support concerted action connected to waivers of exclusivity between Gray Line and Big Bus. This is the best they have. The One World Observatory said it had an exclusive with Gray Line. Big Bus also sold tickets, and the One World Observatory decided not to partner with Go New York, all at unspecified times.
Well, do you think it would be a little difficult for them to come up with more proof, given the nature of conspiracies and how secretive they are, without getting to a discovery stage?
Well, Judge Singas, I'll put it this way. They need to plead facts that support concerted action to survive a motion to dismiss, and they haven't done that. So absent some allegations of contacts, coordination, they can't
So in
survive
your
a
mind,
motion
they
to
haven't
dismiss.
met the Mobil Oil baseline requirements?
No, they haven't, Your Honor. For these reasons, State v. Mobil defined an arrangement as a reciprocal relationship of commitment. There are 2 problems here. There aren't facts that point to a connection between Gray Line and Big Bus or a relationship between them, but more fundamentally, there aren't any facts that connect allegations of a relationship between Gray Line and Big Bus with any of the alleged vertical pressure, whether related to exclusivity or not related to exclusivity for any of the attractions.
What about the allegation in paragraph 35 that with regard to Top of the Rock,
Yeah.
that Top of the Rock said, we're not going to deal with you, Go New York, And if you want to change that, go talk to the president of Gray Line.
Your Honor, an allegation that the tourist attraction said, talk to the president of Gray Line, is not an allegation that the president of Gray Line is colluding horizontally with Big Bus.
Well, clearly, they're not in the same business horizontally, Top of the Rock but that does infer that there's some arrangement, right, where Top of the Rock has ceded its authority to partner with people to Gray Line.
To the extent they are alleging that relationship as something that violates the Donnelly Act, it's a vertical relationship.
Yeah.
It's treated much more leniently
Yeah.
than a horizontal one. Under the antitrust laws, they'd need to show market-wide harm to competition under global reinsurance to do that. They haven't come close to that because they only plead harm to themselves.
Will you pair that, though, with the various horizontal reciprocal exclusivity and the refusals? I mean, there are other refusals that don't specifically say, we have an exclusive relationship, but they say, we don't want to annoy our other trade partners, those sorts of things.
Sure.
You wrap that all up, isn't that enough to suggest that, especially if you believe, as we have to, the allegations of the complaint,
Yeah.
that Gray Line and Big Bus are not shutting each other out, right? They're waiving exclusivity, or at least they're partnering with all these same tourist attractions, and Go New York is the only one shut out of all this, and using different sets of words different times. Why isn't that, plus the vertical, enough?
Judge Wilson, this is the point of the argument about parallel conduct in our brief. It's a neutral fact from an antitrust perspective that they were turned down by a handful of tourist attractions at unspecified times. I mean, these are businesses that are in the same position. They're evaluating a partnership with Go New York. It's rational for them to make a decision about whether they want to partner or not in the same way. What you don't have that you need to state a Donnelly Act claim under New York procedural and substantive law is facts that support concerted action on top of that. So some indication that Gray Line and Big Bus had a relationship with each other and that was connected to efforts to get tourist attractions to exclude them. You don't have any facts that support either of
Counsel,
those? Yes.
this is not my world at all. And I understand the argument you're making, but it seems to me that people don't, if they're colluding in a horizontal fashion like this, they don't advertise that fact. That's not something you want people to know. And it further seems to me that if you want to find out about it, you kind of need to see some text messages or emails or so. That's where you might discover some evidence of it. So can you just explain to me how a successful claimant might allege these facts in a way that would be sufficient? Because I don't understand what's missing in their claim.
Of course, Judge Canataro, here's what you'd need. You'd need facts that show coordination, and here's where 3013 comes in. This is insufficiently particular to show coordination. They make these allegations about exclusivity, but there's no time. I mean, these attractions transitioning from exclusive relationships to non-exclusive relationships, we don't know if they're in any kind of temporal proximity to each other to suggest that, exclusivity and waivers of exclusivity were swapped between Gray Line and Big Bus, and there's only allegations with regard to those
And
two
how
on
would
that front.
one, in the normal course of things, a successful claimant, how would one come across that information?
They could have put facts in, for example, that said, this specific attraction told us that this specific, defendant told us on this date, and then the dates line up in close proximity, and you have,
The theory,
Yeah.
I take it you're saying the theory could be viable, you just think there's not enough specificity with respect to who denied whom access on what date?
those facts would be needed to start bringing it closer, Judge Halligan, but I think the main problem that they would still have is that there are no facts that suggest a connection between the two of them.
Okay, and how absent discovery
Yeah.
might one obtain that, to Judge Canataro's question? I take it you mean something along the lines of a text or email as between the two defendants, correct?
Your Honor, it doesn't need to be a text or an email necessarily, but there need to be facts pled in the complaint that
So
suggest.
how would you come across that evidence without discovery?
You could be much more specific about the experiences that their client had with regard to these rejections and when they happened and what was said to them.
Okay, but that,
Yeah.
I take it, is about the circumstances of the interactions
Yes.
that your adversary has with the attractions
Yeah.
and the responses they get about why they won't do business with them.
Yes.
I thought I heard you say that something beyond that, that more directly evidenced communications as between the defendants was necessary, but maybe you're suggesting that's not the case.
I mean, as an example, in conspiracy cases, sometimes it's alleged these two companies were at the same trade show at the same time, and we know that. I mean, there are particular facts that come up time and again where
The
contact
same
between.
trade show at the same time, and therefore you can infer that they had a meeting during which they conspired?
When a certain quantum of facts are piled up, courts begin to infer that potentially there are horizontal connections. We are way short of that bar here, because there's nothing that suggests any connection.
I'm
between them.
interested if you could, to go a little bit further on your point of the exclusivity contracts, if they could have had some additional facts that might suggest that, I think what you were saying, please correct me if I've misunderstood, if they had something else that, from which, factual allegations, from which either the facts expressly or one could infer that there are indeed these exclusive contracts that are not abided by with respect to the other two big bus companies, at the time that they allege they are informed by a representative from the attraction that they will not do business with them. Is that what you were saying? Something like that would be enough?
That would be a start, Judge Garcia, but that still wouldn't be enough because it
Leave that
wouldn't
up,
put.
but thank you. It's okay, go ahead.
Garcia's over there.
Oh,
Yes.
I'm
Rivera's
sorry,
over here.
Judge Rivera.
It's okay.
That would be a start, but it would not be enough to put a reciprocal relationship. It would not be enough to plead a reciprocal relationship between them, and it would not be enough to put that reciprocal relationship in connection with any of the allegations of vertical pressure
So,
on tourist
okay, if they
attractions.
said that,
Yeah.
then what else might, I think I understand your point that they might be able to get without discovery. They might have some way, and maybe they only need to do it for one or two attractions, not for every single attraction that's involved in this market. Then what would be the plus? You're saying there's a plus that needs to go with that. What might that look like? Given the nature of this industry and,
Yeah.
and what they're claiming they believe is going on, and they want an opportunity to prove that.
If they said, for example, so these allegations are non-specific as to the time in which any of this happened. If they said, all of these rejected us within a short amount of time,
I see.
that would be potentially something from which you could infer this, but
Because it's looking like it's not just happenstance, and it's looking like it's not just perhaps business choices that have nothing to do with arrangements that would be in violation of the statute. Am I understanding that part of what you're arguing?
yes, I think that's something where you could say, on a reasonable reading of the facts, we're going to infer that this was coordinated, but we're not close to that. And this is public information. We don't need to rely on this, but the court should be aware that Go New York's website, topviewnyc.com, shows that it's currently partnered with the Empire State Building and the One World Observatory and the Intrepid for its attraction pass. It's not true that they're cut out of all of the attractions in the complaint.
What's the share, if you know, of the market that, not their company, obviously, the other two companies have?
So, Your Honor, it's in flux. The facts are not in the pleadings that would allow us to know. What I can say is that there is a new tour bus entrant, and our client's bus business has shut down because of the COVID pandemic, and the ticket business is still open. So the market is dynamic, and new parties are entering, and they're obviously,
This really comes down to the tickets more than the buses, right? Because I imagine buses can still take people anywhere. The streets are public, you don't need anyone's permission to use that. It's about these special discounted passes, right?
that seems to be the allegation, is who can we partner with for our pass?
Right.
So,
Yeah, they become more sorry to use that, they become more marketable, they'll get more share of the market. Of course, if I wanted to ride their bus and they're saying, look, these are all the attractions that have partnered with us, and then I go to another bus company and they say, we've got double the attractions, or I've got the hot attractions, and they're not able to get the hot attractions that
Right.
everyone wants to go to, right? That's sort of what's going on with the attractions.
It's true, although they do plead that they've grown rapidly since entering the market in 2012, and that they have become roughly equal as of the time of the pleadings in size and revenues with the others. So it doesn't appear just from the facts in the complaint that having differentiated passes has had a competitive impact on them, and it's clear that also they're achieving these partnerships.
I'll show my business ignorance, which will not surprise any of my colleagues with these questions. Why would an attraction buckle under, let me put it that way, to what they allege has happened? Why would you, doesn't the attraction have the leverage? Because people want to go to your attraction? They don't care what bus gets them there, but they just want to go to your attraction.
So just going on the facts that are alleged, I
yeah.
cannot tell you why a particular attraction
Fair enough.
made the particular choice that it did.
Okay.
But they're alleging that there is no rational business reason that would lead them to do that. I think, to Judge Rivera's question, and I understand we're at the pleading stage, but there's not something that is apparent that you want to share with us.
I would say the following. The conclusion that there's no rational reason, therefore there must be a conspiracy, there are two ways of seeing that. It's a legal conclusion. It's the equivalent of having a sentence that said, this happened, therefore they violated the Donnelly Act. The language conspiracy comes straight from the pleading standard in the First Department. It's also, if you look at the New York motion to dismiss cases, can they succeed on a reasonable view of the facts? Justice Schechter, when she rejected that inference of conspiracy, was saying, this is not a reasonable view of the facts. She was empowered to make that determination when she rejected that, and she was not applying federal law and saying you need to plead facts that rule out other reasons they might have done this. She was
But
just
it's a
saying,
de novo question of law for us, whether or not the complaint satisfies our liberal pleading standard.
correct.
Okay.
Your Honor.
Okay. But just following up on this, I
Sure.
take the argument to be that they say, look, everything we've said means that at a minimum, you can draw the inference that, yes, these other two bus entities are conspiring, have an arrangement, have an agreement to ensure we don't get access to these attractions. And I think your point in your briefing was, they may have other reasons. Yes?
I'm sorry. can you-
The attractions may have other reasons, business reasons, even assuming for one moment
Yes.
that they are indeed specifically choosing not to do business with his client, but to do business with one or both of these other entities.
That's right, Your Honor. The rational, and there were a number of facts in the pleadings that suggest maybe why that was the case. They were a new entrant. These businesses already had multiple partners. Perhaps they didn't
So,
want to.
so under our liberal pleading standard then, however, regardless of whether or not there might be other reasons, does it boil down to the question whether or not he's just made enough allegations that you can infer, factual allegations that one could either expressly or infer from those allegations that there might be something to his reason?
Your Honor, I would not make it about the reason. I would say, the pleading standard is liberal, but it has limits. You need facts to support every element of a claim. You don't get the benefit of conclusory allegations. It has to be sufficiently particular, and inferences are made subject to it being a reasonable view of the facts in the complaint. So I would say you need factual matter in the complaint to support the element of concerted action, a connection between Gray Line and Big Bus that is somehow then brought into relationship with the vertical pressure on the tourist attractions. That's missing at both stages, and that's why we think under the pleading standards, they don't have a Donnelly Act claim.
What do you make of the distinction between arrangement and conspiracy? I know what we said in Mobile Oil, but in your view, how does that translate into what one would need to plead to allege each of them, or is it the same?
Your Honor, I don't think it's that far, and to the extent that the Donnelly Act is broader than the Sherman Act because of the addition of the term arrangement, and to the extent that notice pleading is more liberal than Twombly, we know because of the basic motion to dismiss
In
case
Mobile
law.
Oil, we
Yeah.
do suggest, I think, that it's broader because Mobile Oil says that arrangement is similar to but not embraced within what we call the more exacting terms, contract, combination, or conspiracy.
We agree it's
Which suggests to me
broader.
it's, okay. So what does that translate into in terms of kind of practical pleading requirements in your view?
It would mean in that court's language that you need a commitment between two entities and that routine bilateral business dealings don't cut it. Mere bilateralness, as the case says, isn't enough. There has to be some kind of commitment, and there are no facts to support that here. And we accordingly say that they don't have a case under the,
But you think the same types of facts, there's not a difference in your view about the sorts of facts that would evince a reciprocal relationship of commitment and a conspiracy?
no, Your Honor, and we're not aware of any case law that suggests that this particular constellation would be a conspiracy where, or, I'm sorry, an arrangement where something else would not. In concluding, a number of judges have looked at this under federal and state law and concluded that the facts don't support an antitrust claim, and we request affirmance of the First Department. Thank you.
Thank you.
I'll be brief, Your Honors. The problem that I have is I believe the Donnelly Act, as a matter of policy, wants lawyers like me to file complaints to support the New York policy of free market competition. But how do I draft the complaint with sufficient detail to satisfy my friend? I don't have emails. I don't have text messages. I can only infer from the business environment that my client endures that something must be going on. And I don't have I'm not just guessing.
But
But
doesn't it just
counsel-
boil down to whatever the representative from the attraction said? Because otherwise, they just don't want to do business with you.
No, Your Honor, there's more to it than that, because it's not just one representative. There's a pattern
But
throughout
that's
the
what I'm
industry.
saying, isn't that, oh, I'm sorry, I'm sorry.
Well, I'm
Go ahead.
sorry, Your Honor, but I don't mean to interrupt. There's a pattern throughout the industry, number one. And number two, we have these two instances where exclusive arrangements are being shared. That is, to me, a smoking gun, if you will, that there is some concerted action going on here. I believe at the pleading stage, I should not be required to do more. I don't have the text messages. I don't have the emails.
Where exactly are you alleging that exclusive relationships are shared?
In paragraph 37,
Uh-huh.
for example, and also with regard to Madame Tussauds exhibit. Madame Tussauds is the big bus side of this. Madame Tussauds is exclusively owned by Big Bus, and yet they let Gray Line in. So they're sharing their exclusive rights with Gray Line.
So in paragraph 37, you say that One World Observatory told you that it has an exclusive relationship with Marmerstein, I think, at Gray Line. Where are you, and then is your point that when you say counterclaim defendants also advertise and sell One World Observatory admission, is that where you're alleging sharing?
Correct. That means that they are allowed in the door. Despite the exclusive relationship, they have been allowed in the door. And of course,
Saying that others are allowed in, but you're not, which shows sharing.
that's correct. And it must be, because they have knowledge of each other. This isn't happening in secret. The One World attraction is a big deal in the New York market. It's one of the most valuable attractions that there is. And here, Go New York is shut out, and these two guys are sharing it. That seems to me to be pretty powerful evidence that there's something concerted going on. And certainly it should be enough at the pleading stage to allow me to conduct discovery. And here's the policy issue. How do we enforce the Donnelly Act if at the pleading stage, we impose these requirements that essentially make me prove my case at the pleading stage before I get
But
discovery?
you're not arguing for a standard lower than the New York pleading stage, right?
No, I'm arguing for the same standard, but the New York standard is much more liberal than the federal
Understood,
standard.
understood that argument.
And I think that under that standard, we have more than satisfied it. I mean, if this was a discrimination claim, for example, and you show a disparate impact, that's enough to allow the discrimination claim to go forward. Well, we've shown disparate impact here. We've at least done that. Why shouldn't I be allowed to prosecute this case? Now, maybe at the summary judgment phase of this case, I will lose. Maybe I'm wrong about it.
What I
But
think I'm struggling with here, counsel, is that line between, I mean, the pleading stage, there are requirements, even under the New York liberal pleading standard, and enough to get by that standard without imposing too high a burden, especially given the aims of the Donnelly Act, but more than I allege the secret conspiracy, so how do you expect me to prove it now?
Well, my red light is on. May I answer this, Your Honor?
Go ahead.
Because we've alleged way more than a conclusory conspiracy. We go through 10 attractions. We have separate paragraphs on each one where we talk about why Go New York is shut out. We then have the paragraphs that talk about the sharing of certain of these attractions. I think that specificity should be sufficient under the liberal pleading standard of the state of New York.
Thank you.
Thank you.